Good morning.
The court is now in session. Reference number 19 of 2018. Garang Michael Mahok, as Attorney General of the Republic of South Sudan.
Good morning. Representation, please. Representation?
Yeah. The one we agreed with my grand colleague that I should be making the introduction.
Okay, go ahead.
Thank you. Thank you, my lord. The parties to the reference number 19 of 2018 are represented by Mrs. Esther Mogwai Monaro, who is in present.
Esther or Esther?
Esther.
Okay.
Esther Mogwai Monaro.
Okay.
And Mr. Donald Dyer, who is not present because of some other engagement.
No, just introduce the councils who are appearing today.
Mr. Mogwai Monaro, myself, Yong Piang Kwal, Esther on behalf of the applicant, and me myself on behalf of Yong Piang Kwal on behalf of the respondent. My lord, the attendance is in place, and the parties are ready to proceed with the proceedings. Thank you.
Thank you, Bill. The matter today is for delivery of judgment. The judgment of the court is ready, and I'm going to read it. Mr. Garang Michael Mahok, the applicant, filed this reference against the Attorney General of the Republic of South Sudan on 12th October 2018. It was preferred under Articles 6C and D, 7.2 and 27 of the Treaty for the Establishment of the East African Community, and Rules 1, 2, and 24 of the East African Court of Justice Rules of Procedure 2013. The reference was brought on behalf of one Mr. Kebino Agok Wall, Mr. Wall, who is the subject of this reference. The applicant identified himself as a national of the Republic of South Sudan, who at the time of filing the reference was residing in Nairobi in the Republic of Kenya. He's also said to be a personal friend of Mr. Wall, the latter being a citizen and resident of South Sudan. The applicant prayed for a number of orders and declarations which are contained in our judgment. The reference having been filed pursuant to the 2013 rules, the applicant did not depone an affidavit in support of the reference. He also did not testify in court in the course of the hearing. The respondent filed a response to the statement of reference on 3rd January 2019. Likewise, no oral or affidavit evidence was tendered on behalf of the respondent. Representation. Mr. Donald Dyer and Ms. Praisegod Joseph, Lane advocates, appeared on behalf of the applicant. The respondent was represented by Mr. Byong Pieng Kol, the Counsel General. The applicant's case. The applicant's case is contained In the statement of reference filed on 12 October 2018, the applicants rejoined that the respondent's response and the affidavit in support of statement of reference by Dr. Robert A. Portada, dated 5th October 2021. As it can be gathered from the statement of reference and the other documents from the applicant preferred the reference on behalf of Mr. Wall, who in this case is called the subject. However, in the relief sought, he appears to be craving the reliefs for the applicant and not on behalf of the subject. We believe that this was inadvertent. We therefore consider any reference to the applicant in the relief section of this reference to be in reference of the subject, Mr. Wall. It is the applicant's case that he was a personal friend of the subject of the reference, introduced himself as the coordinator of Nile Foundation, a non-governmental organization in South Sudan. The subject of the reference is introduced as the founder and chief executive officer of the Kelbino Agag Security Service, CAS, and the CAS group of companies headquartered in Juba, the Republic of South Sudan. That Mr. Wall was arrested and detained from the 27th April 2018 after being summoned by the Director General of the National Security Service, Mr. Akol Cook. That at the detention, Mr. Wall was tortured, was not given medical attention, and was not informed of the reasons for his arrest. That he continued to be held despite the revitalized agreement on the resolution of conflict in the Republic of South Sudan of 12 September 2018 and the Republican Order number 17 by the President of the Republic of South Sudan of 27 September 2018, which had expressed provisions to provide relief for those in Mr. Wall's position and others in situations similar to his. That Mr. Wall and other prisoners organized a peaceful protest demanding their right to due process on 7th November 2018. That it is on the same day that the respondent, through its Internal Security Bureau, acknowledged that it was holding Mr. Wall pending Internal Security Bureau court-martial. That on 11th October 2018, the Bank of South Sudan, acting under the orders of the National Security Service, ordered the closure of all of Mr. Wall's bank accounts without giving reasons for the order. The respondent's case. In reply, the respondent contested the reference and contended that it was filed out of time, contrary to Article 30, Subarticle 2 of the treaty. That the subject of the reference is an active officer in the rank and file of the National Security Bureau, Internal Security Bureau, with the rank of captain. That he was involved in the purchase of sophisticated equipment without prior knowledge of the National Security Service using his private security company known as CASI. That Mr. Wall was involved in huge business activities in contravention of the National Security Service Act of 2014, for which the National Security Service has the right to discipline him if he goes contrary to law. The respondent further contends that Mr. Wall's case is different from that of the other political detainees, as his case is purely that of indiscipline of an officer of the National Security Service, and that it is not covered by the revitalized agreement of 12 September 2018 or the Presidential Decree number 17 of 2018. That Mr. Wall managed to smuggle a pistol in his possession into the detention facility, used the same to detain the detention guard, broke into arms store, took 17 rifles and spearheaded the mutiny in the said detention facility, which was taken over for some considerable period of time, after which the National Security Services managed to restore the situation. That this act of mutiny engineered by Mr. Wall would have plunged the country into a bloody path if it was not properly handled by the national security. that the closure of Mr. Wall's bank accounts was dictated by an investigation carried out in accordance with Section 5 and 13(2) of the National Security Services Act of 2014. That the reference ought to be dismissed as Mr. Wall was detained and confined in the National Security Service facility in connection with offenses in violation of Article 4(2) of the Transitional Constitution of the Republic of South Sudan 2011 and Section 56 of the National Security Services Act of 2014. Issues for determination. The following issues for determinations were agreed upon. Whether the Honorable Court has a jurisdiction to entertain the reference, whether the reference is time-barred, whether the respondent's actions constituted a violation of the respondent's domestic law and, therefore, violating Articles 6D and 7(2) of the treaty, and lastly, whether the parties are entitled to the remedies. The court's determination of the issues. Before dealing with the issues outlined above, we find it pertinent to comment, albeit briefly, on the conduct of the parties and their advocates in prosecuting this reference. After filing this reference in October 2018, the applicant filed application number 20 of 2018, seeking interim orders, amongst them that the respondent either releases Mr. Wall or arraigns him before a competent, impartial, and effective court or tribunal, and pending determination of the reference, the respondent, with immediate effect, reverses the closure of Mr. Wall's businesses and personal and corporate bank accounts. The court, after an inter-party hearing, declined to grant the interim orders sought. It directed that the reference be fixed for hearing. As earlier stated, the scheduling conference was held on 25th November 2020, whereby the court directed counsel for the parties to finalize the scheduling notes and consequently proceed with filing of affidavits and written submissions. The applicant was to file his affidavits by 11th January 2021, and the respondent to file his affidavits by 10th February 2021, and in case of an affidavit in rejoinder, in reply by the applicant, the same was to be filed by 25th February 2021. The court further directed that the applicant puts in its written submissions by 25th March 2021, then the respondent puts in theirs by 26th April 2021, and in case of a rejoinder by 10th May 2021. The timelines set by the court were not complied with. No reasons were given, and none of the parties made any application for the court's consideration. The scheduling notes were not finalized until 23rd September 2021, 6 days before the reference came up for hearing. On 29th September 2021, during the hearing, counsel for the applicant made an oral application to adjourn the hearing. He stated that he had encountered challenges in getting witnesses, but that he had gotten some witnesses who were willing to testify. He requested for 7 days to be able to file witness statements, affidavits, and documents. Counsel for the respondent requested for a month's time to respond. The court expressed its disappointment but allowed the prayers. A schedule of written submissions was also made, whereby the applicant was to file submissions by 19th November 2021, the respondent by 20th December 2021, and a rejoinder, if any, by 3rd January 2022. Counsel for the applicant filed one affidavit by one Dr. Robert A. Potada III, an associate professor at Kutztown University in the United States of America, on 6th October 2021. The respondent did not file any affidavit or witness statement. Written submissions were filed very late. That is, the applicant filed on 10th February 2022 instead of 19th November 2021, while the respondent filed theirs on 29th March 2022. On 4th April 2022, this reference was scheduled for submissions highlights. Again, counsel for the parties came up with a number of excuses beseeching the court to condone the delays in the interest of justice. The court reluctantly acceded, but as it can be gathered from the events preceding the highlights, there is insufficient, if any, evidence to enable the court to determine the issues framed for determination. We'll now address the issues as framed for obvious reasons. We'll combine issues 1 and 2. Issues 1 is, does the court have jurisdiction to determine the reference? And issue 2 is the reference time valid. Although the issue of jurisdiction was distinctively listed as one of the issues for determination, no evidence or submission was laid to suggest that this court does not have jurisdiction to determine the reference, other than a contention that the reference was filed outside the prescribed time. It is on that premise that we have decided to deal with the issue of jurisdiction and time limitation jointly. In the response filed by the respondent on 3rd January 2019, the issue of reference being time-barred was made. It was the respondent's view that as the subject of the reference was arrested and detained on 27th April 2018, and as the reference was filed on 12th October 2018, about 6 months later, then the reference cannot be adjudicated by this court, as doing so would contravene Articles 32 of the treaty. The applicant, on the other hand, opposed the assertion, contending that the reference was filed within the 2 months prescribed by the treaty. In his rejoinder to the respondent's response, he firmly stated that the applicant's case against the respondent was premised on the following. 1, failure of the respondent to release the subject as required by the revitalized agreement on the resolution of conflict in the Republic of South Sudan, which was signed on 12 September 2018. 2, failure of the respondent to release the subject as directed by the President of the Republic of South Sudan, His Excellency Mr. Salva Kiir Mayardit, through his Republican Order or Decree number 17 of 27 September 2018. And 3, the respondent's failure to protect rights of the subject, which were violated by the unlawful closure of his personal and corporate bank accounts, and also all of his businesses on 11th October 2018. Before delving into the submissions made by advocates of the parties in this respect, we find it imperative to reiterate the jurisprudence of this court relating to the issue of jurisdiction. The jurisdiction of this court is stated in Article 27(1) of the treaty as follows. The court shall initially have jurisdiction over the interpretation and application of this treaty. Further, Article 30, Sub-1 of the treaty provides for references to the court by legal and natural persons as follows. Subject to the provisions of Article 27 of this treaty, any person who is resident in a partner state may refer for determination by the court the legality of an act, regulation, directive, decision, or action of a partner state or an institution of the community on the grounds that such act, regulation, directive, decision, or action is unlawful or is an infringement of the provisions of the treaty. From the 2 provisions of the treaty cited above, this court has jurisdiction to interpret and apply the treaty in the case of a reference by a legal or natural person that is resident in any of the partner states, where the impugned act is an act, regulation, directive, decision, or action of a partner state or an institution of the community, on the ground that such impugned act is unlawful or is an infringement of the provisions of the treaty. This court, in the case of the Attorney General of the United Republic of Tanzania against Anthony Callist Com, ESJ Appeal number 2 of 2015, delineated 3 types of jurisdiction, which are ration personae, ration material, and ration temporis. It explained them as follows. Lack of ration personae would arise where one of the parties is devoid of the requisite capacity or locus standi to appear before a court. On the other hand, the court's ration materiae may be questioned on the basis of the invoked subject matter, an international court having no ration material to try a matter where the treaty or convention under which it derives its mandate does not grant it jurisdiction over designated actions. In the case of the Treaty for the Establishment of the East African Community, such ration material is outlined in Articles 30, 31, and 32 thereof. Ration temporis, on its part, refers to time frame prescribed for the institution of cases in a court. Further, in the case of the Attorney General of the United Republic of Tanzania against African Network for Animal Welfare, ESJ reference number 9 of 2010, the court stated, jurisdiction is a most, if not the most, fundamental issue that a court faces in any trial. It is the very foundation upon which the juridical edifice is constructed. The judicial edifice is constructed, from which springs the flow of the judicial process. Without jurisdiction, a court cannot take even the proverbial first Chinese step in its judicial journey to hear and dispose of the case. There are a number of decisions by this court where the court has categorically stated that it considers determination of the issue of jurisdiction paramount. It is the first and fundamental question that we determine before going into the merit or otherwise of the matter before us. In this reference, we note from the pleadings and submissions made by the respondent that the jurisdiction contested is a ration temporis. The respondent's counsel concedes to the other aims of jurisdiction of this court in his written submissions and the oral highlights made in court. Article 30, Subarticle 2 of the treaty provides, the proceedings provided for in this article shall be instituted within 2 months of the enactment, publication, directive, decision, or action complained of, or in the absence thereof, of the day in which it came to the knowledge of the complainant, as the case may be. To satisfy the court that the reference was made within time prescribed under Article 32 of the treaty, the applicant has to state succinctly when the decision or action complained of took place or when it came to his knowledge. The appellate division of this court, while dealing with the issue of computation of time, in the Attorney General of the Republic of Kenya against Independent Medical Legal Unit, ESJ Appeal number 1 of 2011, held that time would start to run 2 months after the action or decision was first taken or made. This position was affirmed in the case of the Attorney General of the Republic of Uganda and another against Omari Awadhi and 6 others, ESJ Appeal number 2 of 2012, where it was held that the starting date of an act complained of under Article 30, Subarticle 2 is not the day the act ends, but the day it first effected. It is first effected. In the latter case, the court went further to state as follows. The principle of legal certainty requires strict application of the time limit in Article 30, Subarticle 2 of the treaty. Furthermore, nowhere does the treaty provide any power to the court to extend, to condone, or to waive, or to modify the prescribed time limit for any reason, including for continuing violations. As stated in paragraph 29 above, the applicant maintains that the reference was filed within the prescribed time. This is contested by the counsel for the respondent. At paragraphs 5 and 6 of the written submissions, the respondent avers that since the subject was arrested and detained on 27 April 2018, after he voluntarily presented himself, and since the applicant was aware of the arrest and detention of the subject, the application should have been filed latest on 27th June 2018. In the course of hearing, it became apparent that the issue whether the reference was filed within time was canvassed in application number 20 of 2018 between the same parties. At paragraph 37 of the type ruling, This court stated as follows. As indicated in paragraph 36 herein above, the impugned act, that is failure to release Mr. Wall and failure to protect his property, did happen following the signing of the revitalized agreement on 12th September 2018 and the signing of the Republican Order Decree of 27th September 2018, as well as the closing of Mr. Wall's personal and corporate bank accounts, which took place on 11th October 2018. The reference having been lodged on 12th October 2018, we find that it was filed within the 2 months prescribed by Article 30, Sub-Article 2 of the treaty. We do not understand why the Respondent's Counsel, who had represented the respondent at the hearing of application number 20 of 2018, raised the same issue again. If he was not satisfied with the court's decision on the issue, he was at liberty to challenge it by way of appeal. Much as it may not be palatable to the respondent, this court is unable to vacate its own decision at this stage. To challenge it by way of appeal. We thus maintain our previous position and hold that the court has jurisdiction lesion temporis to deal with this reference. Our decision is premised on the fact that the actions complained of do not relate to the initial arrest and detention of the subject. We are aware that some of the reliefs craved have a bearing on the events of 27th of April 2018. We will deal with the same as and when necessary. Issue number 3. Did the respondent's action constitute a violation of the respondent's domestic law and therefore violated Article 6D and 7.2 of the treaty? The applicant's submission on this issue is that the respondent violated its own laws, namely the Constitution, the Penal Code Act, the Code of Criminal Procedure, the Police Services Act, the National Security Service, and the National Security Services Act. Further, that the respondent violated the revitalized agreement on the resolution of conflict of South Sudan, the treaty and international legal instruments, that is, it is part 2. To substantiate the above claims, counsel for the applicant contended that the subject was arrested and held incommunicado without any access to his family, doctors, or his lawyers until October 2018, when the respondent disclosed his whereabouts. He referred this court to decision in Weisman Lanza and Alcides Lanza Pardemo against Uruguay, and Praxeda Rugumba against the Secretary General of the East African Community, reference number 8 of 2018. Although counsel for the applicant had intimated that the applicant's claims were limited to failure by the respondent to release the subject pursuant to the revitalized agreement on the resolution of conflict in South Sudan, the Republican order by the president, and the confiscation and freezing of the subject's properties and accounts, his written submissions and the highlights thereof covered previous acts regarding the arrest, detention, and failure to arraign the subject in court. These earlier acts, in our view, fall outside the ambit of what was agreed as the cause of action, as they would bring up the question whether the reference regarding those acts was filed in time pursuant to Article 30, Sub-Article 2 of the treaty. On the other hand, counsel for the respondent submitted that the respondent did not breach any domestic law, the treaty, or international legal instruments. In his view, the respondent was merely implementing the law as the subject had been accused and charged of contravening the National Security Act and the penal laws. He submitted that the subject was in fact tried, defended by a lawyer, and was convicted and sentenced to 10 years imprisonment, a sentence that was later pardoned by the president. Counsel for the respondent further contended that the subject was an active officer in the National Security Service and was therefore prevented from indulging into private business not sanctioned by the national security. that the subject is not in the category of persons referred to in the revitalized agreement on the resolution of conflict in South Sudan and the Republican order by the president. That those instruments related to political detainees are not persons such as the subject. In a rejoinder submission, Counsel for the applicant reiterated the applicant's case and faulted Mr. Byong for adducing evidence from the bar, having filed no affidavit in support of the contentions made in court. Having outlined these submissions regarding this issue, the court is bound to decide whether it was supplied with sufficient evidence to determine the allegations made by the applicant. As earlier stated, the conduct by both counsel left a lot to be desired. The only evidence tendered is the affidavit of Dr. Robert Portada III, attested on 5th October 2021 in the United States of America. The applicant did not attest any affidavit or provide a written witness statement. When the court asked the counsel for the applicant why such evidence was not procured, he replied that the applicant had filed an affidavit in the introductory application, but later assigned Dr. Robert Portada III, who is also a director of the Nile Foundation, to put in comprehensive affidavit. The affidavit sought to be relied upon, in this court's view, falls short of the standards required of an affidavit to be relied upon for serious allegations of abrogations of rights. The affidavit contains hearsay statements which cannot be by themselves be relied upon to make a determination of the issue in question. At paragraph 13 of the affidavit, the deponent states that I'm aware that on 27 April 2021, Mr. Wall was arbitrarily arrested and unlawfully detained by the National Security Service of South Sudan, hereinafter NSS, under the orders of the Director General of NSS, General Akol Cook, hereinafter General Kur. I was given this information by various contacts in South Sudan and confirmed in news reports in the days following the arrest, and Mr. Wall confirmed this to me via telephone in the months and years following the arrest and detention and after his ultimate pardon and release from prison. By the above paragraph, the deponent confirms that he was not in South Sudan during and after the arrest of the subject, and that he actually spoke to the subject in the months and years after he was pardoned. The affidavit also states that the subject died after he was pardoned. It does not state when he died. In paragraph 24 thereof, the deponent confirms that he used to speak to the subject even before he was released from prison. With respect to this issue, the affidavit only refers to the seizing of Mr. Wall's premises and bank accounts in paragraph 18 thereof. It does not state whether Mr. Wall was a political prisoner who was entitled to be released from following the revitalized agreement on the resolution of conflict in South Sudan and the Republican order by the president. This court has had the opportunity to discuss what an affidavit should contain in Media Legal Defense Initiative and 19 others against Ronald Mbuusi, deceased, and the Attorney General of the Republic of Uganda, application number 4 of 2015. Where an affidavit contains information that is not within the deponent's personal knowledge, the court will be entitled to disregard such evidence unless there is cogent evidence to corroborate such evidence. In this reference, it is alleged that the subject of the reference was a political detainee, thus entitled to be released upon the signing of the revitalized agreement on the resolution of conflicts in South Sudan and upon the proclamation of the Republican order by the President of South Sudan. It is the applicant's contention in the statement of reference that failure to release the subject contravened both the laws of South Sudan and consequently the treaty. That evidence is not contained in the affidavit supporting the reference. One would have expected the applicant to procure evidence to prove that the subject was a political detainee and not otherwise. We note from the affidavit presented on behalf of the applicant that the subject was able to speak to the deponent and other persons while in detention and even after he was released upon being pardoned by the president. We are not made aware of the reasons which prevented the applicant or his counsel to obtain an affidavit from the subject before he died. We are also not made aware of the reasons why the applicant did not seek to amend the reference after the subject was pardoned in order to remove parts of the reference that asked the court to order the release of the subject. Other than the affidavit of Dr. Robert Potanda III, there is no other evidence to prove the death of the subject. The court is not informed of when the subject died and whether any member of his family was appointed to oversee his affairs, including the relief sought in this reference. The evidence of the death of the subject was, in our view, indispensable, considering the ramification that some of the reliefs have on the life and liberty of the subject. We also note with great concern the absence of evidence to the contrary by the respondent. It is curious that the respondent could not get a witness to attest the averments that counsel for the respondent put in the response, written submissions, and the reply, and the oral highlights. Failure to bring such evidence depicts, in our view, lack of seriousness of the respondent on matters of grave ramification and concerns brought before this court against it. Nevertheless, the onus of proof lies on the applicant. It is our view that the applicant has not managed to prove the assertions made in the statement of reference. He was duty-bound to prove the allegations contained in the statement of reference. On the aspect of proof, this court in British American Tobacco Limited against the Attorney General of Uganda, reference number 7 of 2017, stated as follows. We are constrained from the onset to underscore a pertinent evidential issue rule. The burden of proof in international claims was articulated in the case of application of the Convention on the Prevention and Punishment of the Crime of Genocide, Bosnia and Herzegovina against Serbia and Montenegro, Judgement ICJ Report 207, page 44, as follows. On the burden of all onus of proof, it is well established in general that the applicant must establish its case and that a party asserting a fact must establish it. As the court observed in the case of military and paramilitary activities in and against Nicaragua against the United States of America, it is the litigant seeking to establish a fact who bears a burden of proving it. Various international tribunals, including the International Court of Justice, have generally and consistently accepted and applied the rule that a party who asserts a fact, whether the claimant or the respondent, is responsible for providing proof thereof. Also, it is a generally accepted canon of evidence in civil law, common law, and in fact, most jurisdictions, that the burden of proof rests with the party, whether complaining or defending, who asserts the affirmative of a particular claim or defense. If that party adduces evidence sufficient to raise a presumption that what is claimed is true, the burden then shifts to the other party, who will fail unless it adduces sufficient evidence to rebut the presumption. In the instant reference, the applicant has not adduced evidence sufficient to enable the court to shift the burden of proof to the respondent. Inevitably, his claims about failure of the respondent to abide with its domestic law and thus violating Articles 6D and 7.2 of the treaty must fail for lack of proof on the balance of probabilities. Consequently, the third issue is answered in the negative. Issue number 4, whether the parties are entitled to the remedies sought. A number of declaratory orders and other remedies were sought by the applicant as shown in paragraph 3 hereof. As stated in the preceding paragraphs, the applicant failed to substantiate his entitlement to the relief sought. On the other hand, the respondent prayed that all claims made against it by the applicant be dismissed with costs. In our determination of the issues, we heard that applicant was unable to prove his claims and thereby he be entitled to the reliefs. Consequently, we are unable to grant any of the reliefs sought. Ordinarily, would be inclined to grant costs to the successful party, in this case, the respondent, in accordance with Rule 127 of the rules. However, taking into consideration the manner in which the respondent prosecuted this case, granting them cost will not save the interest of justice. In the event, we decline to grant the orders sought by the applicant. The reference is hereby dismissed in its entirety. And considering the circumstances of the matter herein, and in exercise of our judicial discretion, we direct that each party bears their own costs. Dated and signed and delivered in Arusha, this 24th day of June, 2022.
Ms. Rice.